Well, good afternoon, everybody. A very warm welcome to our panel. I'm very happy and really honored to be here today to moderate this panel. My name is Ursula Pachel. I'm the Deputy Director General of BEUC, and BEUC is the European Consumer Organization. And I'm very happy we have an excellent panel. I'm sure it's going to be an interesting discussion. Let me, before I hand over to our panelists, let me frame a little bit this discussion. We have chosen the theme, which is the title of the panel is Closing the GDPR Enforcement Gap and Looking at the Enforcement Model of the Future. And this has to do with the fact that we, the European Consumer Organization, we work on policy issues, of course, but we also coordinate the enforcement actions that our members do. In certain cases, we have tried that when there is a European-wide infringement, and we have tried to do that also in data protection infringement cases with the entry into application of the GDPR. So nearly 2.5 years after the GDPR became applicable, we wanted to have a check about how it has worked for organizations representing data subjects. How has it worked for the data subjects? And of course, the big issue here is about cross-border disputes or cross-border inquiries. The GDPR has actually introduced an innovative system to really, respond to the single market where companies can do their activities European-wide. And that's a system of cooperation between different DPAs. It's a system of consistent application of the GDPR, and it comes with this one-stop shop mechanism that should really be positive for the business in particular to benefit from having to deal only with one authority. But we have seen in our activities, in our members' activities, that there are some quite significant shortcomings with this mechanism. When we launched our coordinated action against Google for the processing of location data of its users, that was back in November 2018. The case is with the Irish DPC. Since then, since 1.5 years at least, and I have to say it's not very clear when we are going to have a decision. So this experience, we have put it together in a report that we called The Long and Winding Road. And you see that is already a very telling title. It's on our website, by the way, if you want to have a look. We wanted to discuss, therefore, the experiences with the enforcement of the GDPR. And I'd like to introduce our panelists very briefly. So we have with us Sinan Agdal. Sinan is a digital expert with the Swedish Consumer Association. That's an NGO working on consumer interests at the national and at the international level. And Sinan is an expert dealing mainly with privacy and cybersecurity, but also with e-commerce and the platform economy in general. And the Swedish Consumer Association, I should say, is a member of the BEUC network and regularly takes part in enforcement activities that we coordinate. Then we have, and it's a real pleasure to see her, Gloria Gonzalez Fuster. Gloria is a research professor at the Brussels VUB at the Faculty of Law and Criminology, and she's also a co-director of the Law, Science, Technology and Society Research Group. She investigates legal issues related to privacy, personal data protection, security, and I think she's very well known in the CPDP community. We have with us Jean Gagnier. Jean is a public policy director for Europe for Snap or Snapchat since October 2018. And previously he was public policy director for Amazon. And before that, he was for quite some time at Microsoft at the national level in France, but also European level in Brussels and even international level. And before that, he worked for the French Data Protection Authority, CNIL. And then last, but certainly not least, I have the real honor and pleasure to welcome Andrea Jelinek, who I don't think I have really to introduce here, but Andrea is the chair of the European Data Protection Board, EDPB, and she is also the head of the Austrian Data Protection Authority and has been that since 2014. So a very warm welcome to this excellent panel. So then let's dive into the discussion about experiences with the enforcement of the GDPR. I would like to start with Sinan, coming from the consumer perspective, and would like to ask you, Sinan, what do you see as the problems that you may have faced when representing data subjects with the consumer authority? Or I know that you have been a data subject complaining also yourself. And the Google action that you have undertaken. Please, you have 5 minutes. Thank you.
Thank you, Ursula. Thank you for that introduction. I'm very happy to be here. So just to basically review our experience with GDPR enforcement so far, I mean, it started in late 2018 with this coordinated action against Google that Ursula spoke of. This was an action that sort of was based on work from the Norwegian Consumer Council, in which they could sort of put forth evidence that Google were collecting geolocation data using so-called dark patterns to manipulate and basically fool consumers. So I think that in total, we were 6 or 7 consumer organizations from different member states that filed complaints with our respective DPAs. And you know, I think that part of the reasoning behind us doing these coordinated complaints is to emphasize, first of all, that this was an issue that was affecting consumers everywhere throughout the Union. This was not only in 1 or 2 or 3 countries. This was basically affecting all the consumers in the European Union, probably also globally. And second of all, this is a very serious breach of people's fundamental rights to actually track their location continuously, because it's very easy it's very easy to surmise, for instance, people's political views, religious beliefs, sexual orientation, and so on. But we submitted our complaint to the Swedish DPA, of course, since we're a Swedish organization. And a few months later, in early 2019, they actually started an investigation against Google, which of course made us very happy, because we thought that, okay, the GDPR actually works. This is an effective tool to investigate these kinds of issues. So then we were even happier. In the spring of that same year, 2019, we learned that the Swedish DPA was actually intending to conclude their investigation and issue a draft decision that same fall. But as you may already know, what happened instead was that our complaint, along with everyone else's, was transferred to the Irish DPC in August of 2019. So instead of a draft decision, we found out that we would be transferred to Ireland. This was, of course, because Google had changed their headquarters and moved to Ireland. And we're not here, I think, to debate that specific point. But at that time, I was first told, sort of informally, that the Swedish investigation would be handed over in its entirety to the DPC, so that they would essentially resume where the Swedish DPA had left off. And so we thought that that sounded quite good, because in that case, maybe we weren't that far off a draft decision. But then in February 2020, we received news that the DPC had their own inquiry going on. They're looking at a different time frame than the one that we're looking at in our complaint. And really, we aren't sure how this will affect our complaints. And so that's basically where we stand today. I mean, Google is still illegally tracking the physical whereabouts of millions of consumers on a daily basis. We submitted complaints about this over 2 years ago, and we provided ample evidence thanks to the Norwegian Consumer Council. And there's an almost completed investigation, as far as I know, laying in some drawer somewhere in Stockholm. Meanwhile, in Dublin, they have apparently started a new investigation from scratch. as a complainant, I don't know how that investigation will affect my complaint. So just briefly, what I draw from this experience is that, first of all, parts of the administrative procedure in these cross-border cases should be harmonized so that I, as a complainant, can know what to expect. And we also, as part of this harmonization, we should look at establishing common deadlines so that we can sort of get these cases moving a bit faster. Second of all, there needs to be closer cooperation between the lead and the concerned supervisory authorities. If they don't start sharing the workload during these investigations, I don't think that enforcement will be sort of fast enough to be effective. So that's two initial points I would like to make. Thank you.
Well, thank you very much, Sinan. Thank you for this, for telling the story of your complaint and of the coordinated complaint, and already making some really interesting points. I'm sure we're going to come back to these proposals that you just mentioned. Let's move on then to see what Gloria has to say and giving us an academic perspective. Gloria, please, what do you see as the gaps here? Thank you.
Yes, thank you very much. I do have slides. I hope they will appear. I will continue discussing this question of enforcement in cross-border processing scenarios. I think it is very, very important, and it is quite tragic that we can agree that the GDPR maybe works when it's a domestic case and fails to work when we are addressing, we are in a cross-border situation. It's a regulation, it's part of European Union law. The European Union has this core idea of a digital single market. We are supposed not to move now from home, that we can buy things online from anywhere in Europe. Data flows, things flow, but our rights don't really travel smoothly, and I think that's a problem. So what do I know about all this? I know what I can know, what I can research, and for many years, a couple of years almost, we didn't know much because there was not a lot of information available about how does this Article 60 cooperation through the one-stop shop mechanism work. Everything was known, I suppose, by data protection authorities, but we didn't know much until this great thing happened, which is next slide, please. I clicked on the thing. And so in June last year, one of the highlights of the 2020 was the appearance of the register of Article 60 final decisions in the website, on the website of the EDPB. You have it here. You can just visit this page. It's really wonderful. It's a page full of final decisions adopted through this Article 60 procedure. Remember what this is about. It's, for instance, that you have a complaint. You launch this complaint with a local authority. This goes then to a system where there's a lead supervisory authority that also will deal with the case, and a final decision is taken, and it is published here in this register. You can actually download the document that is a final decision. Not very clear which kind of document it must be. It can be a letter, it can be a final decision document. It's all sorts of documents that you find there. You have even a summary by somebody from the EDPB. It is quite nice, and I thought, well, I'm a happy person. For a little while I was, until next slide, please. Until I scrolled down the website, and then I saw this, and I already started to worry about, does this all make sense? Because so I thought all final decisions were going to be there, but no, they are not all there. Some are not there just because apparently there's a mistake. I click and I get a strange document or a page not found thing, but actually it is explained on the website that you will not have access to some information. So some decisions are anonymized, and that's reasonable, of course. So no information about natural persons, sometimes no information about legal persons. It could be making sense, but then some decisions are not there at all. And then it says, due to national restrictions, I really have trouble understanding which national restrictions on those cases will apply. I really don't see this. The decisions of the Spanish Supervisory Authority are not here on this website. They are on the website on the Spanish Supervisory Authority. So when they publish a decision, they publish it there. There will be apparently a law in Spain saying you can publish your decisions normally, but not when they are taken through the cooperation mechanism. How, why, how is this compatible with European Union law? I would like to have somebody explaining this to me kindly. I sent an email to the DPB, but I suppose they are present. So not a lot of information, but also not a lot of information. We could discuss the limits of this. because I really have a limited time and will not focus too much on the transparency things. Just the next slide, please. To give you an example of the things that one encounters here. Yes, this is actually a document redacted, a document by a data protection authority, which apparently is from a member state where they don't have the right to mention the names of a legal person. So somebody has redacted their own names, so we don't know who they are, but at the same time they are referring to other data protection authorities. So how can it be that you have a law in a member state where you cannot name yourself or your documents, but you can name other data protection authorities? It doesn't make any sense to me, so I would really again like to have somebody to check this, that this is making sense. So, but this is the transparency. You're probably more interested in the content of what we can learn when we go to this register. So next slide, please, Juliana. Thank you. You can. Thank you. So what is this about? In many cases, it's about indeed data subjects just complaining with very small problems. They bought something online, they want to unsubscribe for a newsletter, and they just complain. There are some data breach notifications. Half of those data breach notifications cases are from the same data protection authority in Berlin. Apparently, they have their own independent interpretation of what needs to be notified to the whole of Europe, but that's a specific case. Otherwise, most of the time, it's just a data subject and small, normal, common people having small problems and just going to the local authority, and then having this transposed to lost somehow into the one-stop shop mechanism. How does this end? In general, it ends with this. Next slide, please. We are all intrigued. Yes, so it's here. You can see this pie half empty or half full. So in most of half of the cases, the conclusion is there is no infringement. Half of the cases there is an infringement, and then you could have, of course, a different corrective measure, a reprimand, compliance order. In some cases, a fine, and in some cases, nothing, because it's also possible that there's an infringement, but there is nothing. So doing this slide, it was important for me to show you this slide because it was very painful to do this slide. It is very difficult. If you're familiar with how the data protection authorities work, you know that there is not even clarity about what is an infringement. When do you decide there was an infringement? So sometimes there was an infringement, but the conclusion is that it's solved, so there is no infringement. But sometimes there was an infringement and it was solved, but the conclusion is that there is an infringement. So you really have to be focused and say, what are we saying? And then you can do this slide. I hope you appreciate the slide. It was a lot of work. And then doing these exercises and trying to understand how they work. Thank you. I came here. And this is for me perhaps the most important slide. This is, no, the next one was the good one. Thank you. So the next one is about the cases in which actually the complaint, so there are many cases about complaints, data subjects complaining, and then complaints leading to this decision, there is no infringement, your complaint is rejected or dismissed. These are the cases where this happens. So these are the cases where in principle, Article 60, paragraph 8 should apply. This Article 60, paragraph 8 is very important in the design of the one-stop shop. Why? Because remember, the one-stop shop is about facilitating the life of controllers by having this single point of contact. But it was very, very clear since the beginning that this was a risk for data subjects, that you also had to make sure that data subjects, and we heard from one just a few minutes ago, that they have this communication with the local data protection authority. So this Article 68 is when you lodge a complaint with a supervisory authority, and in the end, your decision is your complaint is going to be rejected or dismissed. It must be the authority to which you lodge the complaint that replies to you. Why? Because then you can contest this decision locally bring the case to the court. Otherwise, we are into this crazy scenario where somebody in a strange country or in a different country is taking the decision. So these are the cases, according to me. In all these cases, this Article 60, paragraph 8 should apply. And you see in green the cases in which actually it has been followed. In gray, in orange, yellow, the cases in which I really think it should have been followed, but I'm not completely sure it should have, because I don't have all the information, because really the register is also not providing me all the details. And in red, all the cases in which I really think there's no way that they did this properly, because they should have followed Article 60, paragraph 8, and they completely ignored it. So the case is dismissed, the complaint is dismissed. By whom? Not by the DPA with whom the data subject of the complaint, but by another data protection authority. this generates huge problems, serious problems, I think, for the data subjects, and especially in many cases, which actually the case is the complaint is dismissed because this lead supervisory authority in Liechtenstein did not receive a reply to their email. They tried to reach you. You did not reply to an email from the Data Protection Authority of Liechtenstein. Did you know that the GDPR applies in Liechtenstein, that you have something to do with them? No, your complaint is rejected. And then what do you do? Well, I don't know. What do you do? I think there's a huge, huge problem. And just final slide, Ursula, I promise, to give you just a clear, simple illustration of the green cases in which which this was followed. The basic rule was followed properly, but still there is room, I think, for improvement, because even when data protection authorities remember about Article 68, they don't really, I think, take seriously enough this idea that they have to help the data subject. And you have here a case where somebody in Germany lodged a complaint with the German Data Protection Authority. The case goes to Ireland. The complaint is lodged with Ireland. The case goes to Germany. Then Ireland remembers, well, we have to take the decision and we have to inform the complainant. So they do. They attach the decision, the part of the decision taken in Germany. And then they give this strange advice. In the event that you are dissatisfied with our decision, you might wish to take the matter further in Ireland or in Germany. And then we suggest that you get your own independent legal advice. I would suggest you also get some yoga classes or something, because if you go to Germany to contest a decision that was taken in Ireland, it's not going to take you very far. I think the DPAs should take this matter much more seriously. The EDPB should take this much more seriously. And I'm happy to discuss this further, but I know I only had 5 minutes, so I will stop here. Thank you.
Well, thank you very much, Gloria. I think that was truly insightful, both on the transparency of the ways to report about the cross-border cases, but also I think it confirms a little bit this idea that the data subject may end somewhere in between, lost in transition, so to speak. So I think that was excellent. So let's move on to Jean. Jean, from the business perspective, you have to comply with the GDPR. How does that work for you, please?
Thanks. So yes, let me share with you this business perspective. But you know what? Maybe just in 1 minute, and I will be very, very short, I promise. I just would like to remind to some of you what Snapchat is and isn't, because you know, the position of Snapchat is so peculiar into this platform environment that I think this is really worth sharing. So Snap, and some of you maybe have downloaded the app. So Snap is a camera company, not a social media. And this is very important because Snap, at the beginning, has been built as an antidote to social media or from social media. You know, the idea from Snap was really for people to communicate via video or via photo with their friends, with a close group of friends, a small group of friends, without the pressure of the fact that the content will stay forever. Because you know that basically a lot of Snap elements of the model, of the business model, is really around privacy for me. And that's something very, very important to bear in mind. This is why I'm always happy to speak about privacy and Snap. Not only because, of course, I used to be a privacy specialist, and I'm still, I think, but also because Snap and privacy goes very well together. Because, so for those that know very well the app, you know that data deletion is Snap defaults. Basically, all Snap and chats are by design or by default ephemeral and are deleted from our server once they are opened or expired. So basically, all our messages are gone in 24 hours in order to try to replicate the privacy and the authenticity of a physical conversation. Also, you know, data minimization, purpose limitation, along with privacy by design and by default, are really working into a concrete practice with Snap. For example, for privacy by design, each feature and product that touch Snapchatter data is reviewed by the privacy lawyer, privacy engineer during the design and the development phases. So there is no feature that is released unless our privacy team approves it. This is just a high-level preliminary, but just to explain to you that this unique business model makes it very appropriate with privacy and, more importantly, with GDPR, because I really see that Snap privacy practice has been aligned with the principles underpinning GDPR for a long time, even from the outset. In fact, Snap, as you can see, was designed to recreate the private communication between friends. And so the core principle of GDPR around data minimization, purpose limitation, short data retention periods, right to be forgotten, etc., reflects our values. Because I think everything here is about values. I love Snap values for other topics. And of course, today we won't speak about online harms or fake news, but this is also something that really reflects Snap values because we differentiate vis-a-vis the rest of the platform. So what I really like with GDPR principle, and where I'm very positive about GDPR, is that the risk-based approach allows certainly our platform, but to remain in compliance with an ever-evolving environment for a lot of platforms. And I mean, it's always good to speak about GDPR, and in fact, it has been a while that I really haven't speak about it. When I was working at the CNIL, as you said, when you make the intro, it was a long time ago. I was working at the CNIL in 2001, so at an age where a lot of platforms were not really live. But I remember that when I was in Brussels in 2010, speaking about GDPR for the first time, we were at the very beginning, of something new in Europe. And when I see today that GDPR is a role model for a lot of countries around privacy all over the world, this is just fantastic. And I remember very well in 2010 when we discussed about new concept around right to be forgotten, one-stop shop, or for example, the notion of accountability. We can see that today this works very well. I remember having discussion with DD Justice where accountability wording was a new concept for all of us because you don't translate accountability the same way in French or in English or in Spanish. So it's very important. So saying that, sorry, and I really would like all of us to remind those positive development. Coming back to GDPR and really what we can think about some issues or where we can think all together about how we can close the enforcement gap. I think today, and everybody would agree on that. And what my colleagues said before is exactly the idea that we can see some lack of consistent approach and guidance between EU and member states, between member states and local DPAs. The cooperation between some DPAs sometimes effectively is a bit complex for some citizens. And what is also important to bear in mind is that I think that some data protection authorities do not have really the resources or the funding to enforce GDPR properly. I've seen my friends at the French DPA have hired a lot, but still a lot or more and more complaints every day is coming. So DPAs are sometimes understaffed. So it's not easy for them to really address all the complaints they would like. And what I also notice is this lack of resource also creates some friction between trust, the data subject having adequate enforcement, and because some complaints can take a while. What Sinan explained on behalf of the Swedish consumer organization is very interesting to hear that more than 2 years to try to resolve a case, which is not normal. I mean, we should expedite more the process. So just to finish on this part, it's really, so the idea is if we think about closing enforcement gap, it's really more about providing regulators with more time to flesh out their investigation, increasing the budget, increasing also transparency on the way regulators are handling the cases, and also explaining better maybe to the data subject why some DPAs are looking after something instead of others DPAs. And we can also take inspiration sometimes from other countries in the world. What the FTC has done in the US is also interesting as being quick and sometimes try to resolve some issues. And I just want to finish on the fact that I think it's also important for data protection authorities to open more often dialogues upfront with data controllers, so that data controllers be informed in due time about the likely enforcement action. And this will also certainly help expediting resolving the issues for some of data controllers. So I'll just make a pause because I think we discuss this later. Thank you.
Okay, thank you very much, Sean. Interesting to hear. So if I understood it rightly, for Snapchat, there is not really a problem with the GDPR. It's easy. but maybe for the authorities it's tough. It would be interesting to discuss also your idea that there should be more dialogues between controllers and authorities. So, but maybe we'll have some time to do that. But I would like to move on now to Andrea. Andrea, you have heard now from the consumer, the business side, the academic perspective. How does it resonate with what the EDPB's analysis is, or maybe your Austrian head-on analysis? So thank you, please.
Thank you, Ursula. Thanks to everybody, and thanks for all the input we just got. Before answering, because there were raised many questions on specific issues, especially from Gloria, I'd like to tell us our point of view, how we see it at the moment. And I think it's really important that everybody from the industry, from the academics, and from the consumer point of view is raised in our panel. I think it is safe to say that there have been many developments in data protection in the last year. And as a result, the COVID-19 pandemic was definitely not a slowdown for the work of the European Data Protection Board. In addition to our guidance on consistency work, the EDPB worked on issues such as the data protection implication of the efforts to mitigate COVID-19 and data transfers after the Schrems II ruling. Importantly, especially in the context of today's panel and the overall theme of this edition of the CPTP conference, we successfully concluded our first Article 65 dispute procedure in November, as you already know, and I'm sure you read it. At the national level, the supervisory authorities are actively enforcing the GDPR. I hereby think of the recent 12 million euro fine issued by the Italian Garante, or the 35 million fine issued by the Hamburg DPA, and especially just this week, the Norwegian Supervisory Authority issued a 10 million euro fine. Of course, the enforcement of the GDPR and the one-stop shop is much more than the dispute resolution mechanism. Or we have to see, because we have more than the cases involving big tech companies or the large fines that make the media headlines. The reality of cross-border cooperation are dozens of bilateral and multilateral exchanges that take place daily between supervisory authorities. The majority of these cross-border cases are resolved via consensus. Up to the end of 2020, more than 500 one-stop shop procedures were launched, and out of which 168 final decisions were issued via consensus. You saw it on the slide, on Gloria's slide, some of them you saw. We can discuss why it is like that later on. This shows clearly that the one-stop shop and cross-border enforcement are working in general. But this doesn't mean that everything is perfect and is working perfectly. In its contribution to the biannual review of the GDPR, the EDPB said that the cooperation and consistency mechanism works well, but that there are some differences in national procedures which can be an obstacle. And Sinan mentioned it, and Gloria mentioned it, and I know we discussed it already last year at the CPTP and a panel in Brussels, which with the Finnish Supervisory Authority and with Max Schrems. We were already speaking about these different administrative procedural laws and the obstacles which we have to overcome in this issue. Within the EDPB, we are working to strengthen the cooperation between authorities by working on harmonized guidance relating to cooperation. In this context, we will implement a coordinated enforcement framework to facilitate joint actions in a flexible and coordinated manner, ranging from joint awareness raising and information gathering to enforcement sweeps and joint investigations. Next, we will create a support pool of experts, which will provide additional expert support for investigations and enforcement activities of significant common interest. This will enhance the cooperation and solidarity between all the supervisory authorities by addressing their operational needs. So I look forward for today's debate and to finding out from the point of view from the consumer side, the business side, and your side from academia. I'm ready to discuss the issues you raised. Thanks.
Okay. Thank you very much, Andrea. We're running a little bit into time issues, but I would like, nevertheless, before opening the floor to the audience to put questions, to go quickly into a second round, because you raised these issues, Andrea, and that you already discussed them last year about the national procedures that maybe need some harmonization. And that was actually also what Sinan said in the very beginning. So maybe let's just look at that a little bit deeper, and maybe just go back to Sinan and to say about from the situation of the data subject now, from all what you have heard. I mean, what do we need? Do we need a review of the GDPR to do more procedural harmonization? Do we need a European administration law to come here with the procedures to help the data subjects to have a clear reference for timelines, for example? What would you say is important here? Thank you.
Thanks. No, I think that first of all, it's important that the EDPB establishes some sort of guidelines. I mean, that's at least the first step, I would think, and having the different DPAs discussing how they can actually cooperate in a better manner. And I picked up a bit on what you said, Ursula, with the complainant being stuck or being lost in between DPAs. I think that that's exactly is what's happening. You know, I'm the data subject myself in the complaint against Google, and in the beginning, I felt that the Swedish DPA was a good sort of counterpart. They explained the procedure to me, how everything worked. But then, as soon as I was transferred to Ireland, that, I mean, for natural reasons, that becomes much more difficult, because then I'll need to engage with the DPC through the Swedish DPA, and then all of a sudden we have a different administrative procedure. And even though I have, you know, wonderful colleagues at BEUC and other consumer organizations, it is very difficult to understand what my rights as data subjects are over there in Ireland compared to in Sweden. But as a short answer, I think that we can start with some guidelines from the EDPB, and then we can work onwards from there.
Okay, thank you very much, Sinan. Let me just pass that question directly to Andrea, because we have her here. Andrea, in what you just explained, in that context now, would there be space like that the EDPB, that the authorities discuss best practices, maybe in the sense of what Sinan just explained, so that we know they have their procedural laws, but of course you can always do more for a data subject in terms of maybe informing about the progress of the procedure, etc., whatever. Would that be something that could be envisaged?
Thank you, Ursula, for the question, and also thank you, Sinan, for raising these issues. What we, the supervisory authorities, want less and really dislike is if the complainant feels stuck between the supervisory authorities, because the GDPR brought you the opportunity not to deal with different supervisory authorities, but to deal with your supervisory authority. And if your complaint has to be forwarded to a different supervisory authority because the company has the head office in this other country, you can always rely on your supervisory authority, and you can always ask your supervisory authority, and the Swedish supervisory authority gets in contact with the other supervisory authority. So you don't have to take care who is dealing with your case, because your rights are the same in all over Europe according to the GDPR. I know this is difficult if you see that you have different administrative procedural laws, but you can rely on your supervisory authority. You don't have to run to Ireland, to Austria, or to Norway because your supervisory authority is running for you according to the GDPR. That's an attempt to answer your question. And the second thing is regarding best practices. Yes, best practices, we are always working on that, but I have to tell always and everywhere and everybody, best practices are not able to change the law. Because if you have different procedural administrative laws, you can't exchange them through best practices. So we are working close together and closer daily. At the moment, we're already working on Article 60 guidelines and also on Article 65 guidelines. We're working on that, and be sure we really look after the consistent application of the GDPR, and we really try all our best. And Jean mentions an issue which is of importance also in 2020 and 2021. Not all of the supervisory authorities are staffed in the correct manner. You read it for sure in our evaluation report of the GDPR that not every supervisory authority has enough money, has enough staff, and has the right resources. So.
Okay, thank you very much, Andrea. We don't have a lot of time, but I'd like to hear quickly from Gloria and then from Jean also about this issue that you just explained again. Of course, in the GDPR, in theory, would foresee that the data subject can rely on the national, on his home or her home DPA, so to speak. In practice, it looks a bit different. We have heard that from Gloria. We've heard it from Sinan. The experience from BEUC is also that when the Irish DPC decided to do an own volition inquiry first, before treating the complaints that had been launched by 7 different organizations, the responsible home DPAs didn't have a lot to say or didn't, comment. So the question would be, what would you say, Gloria? What can be done about this situation?
I think the first thing that can be done is to acknowledge that things are not working, and I think that would be good. That the GDPR says something and the reality is different, and I'm saying this because I'm following the opinion of the Advocate General Bobek. In this case, that a recent opinion was published in the dispute with Facebook, Belgium, and this is about Article 60, and there is a very nice paragraph, which is paragraph 128, saying if one day we will have evidence that this beautiful system that the GDPR has, that was really crafted with a lot of tension, discussions, the council, everybody, if we have evidence that it doesn't work, the court will not turn a blind eye to the fact that it doesn't work, because there's a massive breach of the fundamental rights of data subjects, Article 8, the right to effective judicial remedy. So I think we should not wait for the court in Luxembourg to understand that there have been massive breaches. It's for us to accept that it is not working. Some DPAs are just interpreting, forgetting about this provision, and then is guidance going to solve this? Is guidance given by the data protection authorities, which are forgetting about this provision, really going to be the solution? It's good that somebody reminds them about this, but perhaps more pressure is needed, and not because I don't trust the DPP, but because I think perhaps it would be more effective if more pressure was put on them, especially on this, and thinking which kind of procedures can help palliate the fact that the national procedures are different. Probably we cannot change national procedures. If we had this discussion last year and 1 year later nothing happened, maybe let's change the thing and say, well, maybe just having a system where it's impossible for you to register a decision that it's a rejection of a complaint if you're not the competent authority to do this, will just palliate the fact that the data protection authorities are interpreting things creatively. And so let's not focus too much on the national approaches. The EDPB is a legal authority, has legal personality at European Union level. Perhaps we are happy to put more pressure on this message that they should somehow do something in that direction. And perhaps you, as defenders of the consumers, also in cross-border processing, you should put more pressure on it.
Okay, thank you very much. That's clear. Andrea, I see you want to react directly, or can I give it to Jean?
Directly,
okay,
just one sentence. The Advocate General Bobek, I have the paper here too, but also said that the GDPR is still an infant, and he underlined that it is far too early to decide that everything has to be changed. So also to refer to the Advocate General. And now I'm silent. Thanks.
Thank you very much, Andrea. That's also very important. Of course, we're in the beginning, that is true. But everybody is impatient to see the potential of the GDPR really, taking up. Jean, you have 1 minute. I'm sorry, but I would really like to go back to the audience, and we actually have 5 minutes shorter. I mean, we don't have the full time of the panel. So please, can you do something in 1 minute, please?
Of course. No, and I like very much what Andrea said. I was about to say the same. GDPR is an infant or maybe a teenager, definitely. So you know how teenagers are clumsy sometimes and they need to learn. I've got 3 teenagers at home, so I know that very well every day. They need to learn many things before understanding from their mistakes and how to change. But however, GDPR in itself is a very good vehicle. I don't think GDPR has to be changed. What we said effectively is that maybe what could be changed or what could be improved. And Ellen Dixon, the head of the Irish DPA herself, recognized the necessity to clarify the method used for the designation of the lead authority. So maybe this has to be clarified, but I think really, I see 3 elements that have to be changed or reinforced. The first one already said is the resource. DPAs have to be resourced really like other authorities, like the telecom authorities, like other authorities all over Europe. Second element I can see is really the timeline. Timeline is very important for infringement because we need really to expedite the process. It should be said indirectly that it should not take more than, let's say, 1 year to address and to especially and to clear an issue, especially from a data citizen perspective. I mean, us as a citizen, we don't understand why it takes so long. And it's very important to expedite the process. Moreover, because, and I shouldn't say that, but this is privacy, so everybody will forget that, large platforms profit a lot from the time issue because this is to their best interest to wait longer and longer. Citizens need to profit from something being done very quickly. And just to finish on that, the last element also regards the fines or the way we can punish the companies that are not respecting the law. I think really I think some of us know that fine is not the essence of it. I think fines are not enough. This is maybe a good element, but we should now sometimes take more inspiration from the competitive framework. Competitive agencies are doing that a lot, so maybe this should go with more remedies, offering other business model for the company, offering something more than that, because we've seen that fines just are pocket money for companies, but what they really care, what we really care, is about liability, is about the business model that is at stake. So if the business model itself is put into danger by the data protection authorities, this will change everything. And believe me, this will never happen again. So this is why core elements about privacy by design or by default or data minimization should be always pushed forward by the data protection authorities to say, guys, you need to change your practice, but really at the core of your business. I try to make it shorter.
I think that's an excellent point, actually, that it's probably not really so much about sanctions, but it's rather about remedies that change practices, right? Maybe let's go back to the questions now from the audience, at least for 10 minutes, and see what we can take. There is an interesting question. I'm just going to read it out, and it's to you, Andrea. I'm afraid you will have a lot of questions. So it reads, how will the EDPB ensure that the decision, such as the Norwegian DPA decision against Grindr that you just mentioned also in the beginning, is consistently enforced across member states? That is actually, I think, a very topical question now, because many will have the same question in mind, I think. Andrea, could you say something about the Norwegian decision and how the EDPB will go about it? Thank you.
The enforcement lies with the supervisory authorities, with the national supervisory authorities. So they have to enforce the fine towards Grindr. And we are happy to be part of all of this, but the enforcement lies within the national supervisory authority.
May I just ask, because if I'm a Grindr user,
Yes.
will I benefit from the decision in the sense of I'm affected and that data transmission should stop also for me, from my
Yes,
point
for
of
sure.
view?
Yes, for sure, because Grindr has to put into effect the Norwegian decision in all EEA countries. That's one of the main effects of the GDPR, that it's not that's a decision of the Norwegian supervisory authority, but it has effect in all the EEA. They have
Okay.
to change their uh, their rules of procedures, that whatever it is fine. They have to change it in all countries of the EEA to be
Okay, I think
compliant according to the GDPR and according to the Norwegian decision. That's the
that's good.
sense.
Good news for consumers and for users. I have another question here. It doesn't say to who it is addressed, but I think it's interesting. It says, do you think cooperation between DPAs and CPCs, I guess that means consumer authorities, will contribute to this, e.g. cooperation on guidelines for the industry and for data subjects and consumers as well? Or do you think the role in relation to such guidelines should be for the EDPB and CPC members? I'm not sure I really understand, but I guess it's interesting to see what is maybe a link between data protection enforcement networks and consumer enforcement networks, but I'm not sure I understand CPC in the correct way, but CPC is normally the Consumer Authority Network. Who wants to maybe come in on that question? Anybody volunteers? Not so much. Sinan, yes, please.
Yeah, no, I could just sort of think a bit about, like, as a consumer representative, we're currently looking at ways of actually sort of merging data protection cases and consumer rights cases. And if you look at, for instance, this Google complaint and also the Grindr complaint that the NCC brought recently, you can sort of see that, for instance, when it comes to dark patterns, that's something that affects both privacy issues and data protection and also consumer rights issues. So I think there's a connection there. And perhaps I don't really get the question totally either, but if data protection authorities could maybe find some inspiration in how the CPC network works, for instance, if there's some sort of best practice there. But yeah.
Okay, thank you, Sinan. Gloria, please.
Yes, for me, one of the things that it's one of the major differences that there are with the way in which consumer organizations function and in relation to consumer issues and with data protection is this question of precisely the cross-border scenarios. So my knowledge of consumer organizations is limited, but I know that when I have a problem buying something online from another member state, there is some organization which receives money from the European Commission to support me in my because it's an issue that has European relevance. And it's precisely the opposite of what happens when I have a data protection problem, because when I have a data protection problem, we run into this question, the one-stop shop, the strange borders. So I would love if some of you will receive some support precisely to help data subjects when they have this cross-border processing trouble with the data protection rights. It will, for me, totally make sense from a European Union law perspective. We are supporting consumers in those scenarios. We are not really supporting consumers the subjects in those scenarios, and we are just doing the opposite, just forgetting about them. It's a strange policy decision for me.
Okay, thank you. That's a very interesting thought, Gloria. Thank you for raising that. I see Andrea wants to react. Please, Andrea.
I just wanted to raise the issue that the EDPB, our social media expert subgroup, is already in contact with the Consumer Protection Network for working on joint guidelines.
Okay, that's interesting and good to know. Let me maybe see if there is one last question, because I go back to give you a final chance, so to speak, to say a concluding word. There is a question about timing of decisions. Seems to be a big issue. Do you think the DPAs should try to make greater use of the possibility to adopt interim measures to prevent that the most significant infringement and harms continue for such long times until final decisions arrive? I think that that's also a very pertinent question, and I think I have heard that the interim measures which are in the GDPR foreseen, that they haven't really been used. Who wants to react to that? Andrea, would you like to say something about the DPA's problems to come up, or the EDPB probably, depending on the situation, with more speedy answers to complaints?
The question of speedy answers is also not only a question, and especially not a question for the EDPB, but for the national supervisory authorities, because in some of our countries we have deadlines, very strict deadlines, e.g. in Austria 6 months, and in other countries too. But in some of our countries, there are no guidelines at all in their administrative laws. It's really a big problem, the big issue. And I think we as EDPB, I can't put pressure on a supervisory authority who is working according to their law. I think it's really an interesting issue, because we as EDPB, we are 31 supervisory authorities, all on equal footing, and all with one vote, and with hopefully more and more one voice. But we have to follow different administrative procedure, but we have to look together after the consistent application of the GDPR. But we can't change our administrative laws, and the best practice cannot change administrative laws. It's really an obstacle. We try to overcome it. We try to cooperate even more. We try to find any gaps to fill, which are still legal. I think we are really doing hard work on these issues. You can believe, and we're discussing quite a lot. We are also quite discussing regarding Article 66.
Okay, that's good to know. Of course, I think everybody acknowledges that. Yeah, sorry, Andrea.
As far as I think, as far as you all know, there is this Article 66 issue launched by the Garante on TikTok. Launched last week.
Yes, indeed, and we will see how that is going to play out, because I understand it's not yet for certain. So let's see. But I think that's all excellent points. Really, some obstacles here to overcome, and we have heard some good ideas already. I think we have only 5 minutes left. So I would like maybe just to do a very final round, so that all of you just answer in very few words, basically, to the question of what would be the first single point that you think should be addressed now, and also maybe who should do it, and what could be a good way forward. So maybe this time let's start with Gloria, and then we will go through to come to all of you. But we only have 5 minutes left. Thank you.
So thank you. Very quickly, I'm not sure the GDPR is a child, but if the GDPR was a child, how do we recognize children? They are the ones who learn quickly. So I hope that the GDPR will learn quickly, that we will not have the same discussion forever. And who has to help the GDPR to learn? It's all of us. We have to do this together. Of course, the DPP cannot solve everything. We are happy to manifest ourselves. We need access to information. And when people discuss the Data Governance Act, it's all about, let's give access to researchers to data. And what about access to information for us? Please, I know the DPP has been doing a lot for more transparency, but more transparency still can be done, that we have access to information, that we can read the decisions, that we have a clear view of what it is that we cannot read, so we understand what is happening, and then we can give better suggestions. Thank you.
Okay, excellent. Thank you, Gloria. Jean, would you come next, please?
Yes, sure. So, just to finish, I think one or two message I would like to give as a platform, but also working in other large US companies before. I think what is key on, or what should be key for platform and for companies is trust. So trust is really, for me, the most important word that should come naturally for GDPR. Again, I like very much the GDPR tool. I think it is a role model all over the world. But and the problem really with is not there is no problem, but what should be strengthened for GDPR is really the importance for companies to take into account all the principles. And for that, trust is key because when companies make a choice, a call, they look at the balance, pros and cons, advantage and disadvantage. So if a company see less advantage in trying to comply because there is no really incentive and there is no pressure, then they would not try to comply very quickly. So again, this is why trust is key. And I think that based on this, as I've said before, the business model is the first most important element, but also it will be maybe even more important for data protection authorities to communicate even more the outcome of their decision, because it can take a while before they find a solution. Okay, but what is very more important after that is to communicate this rightfully, especially to the data users, to basically the data to the citizen and user of the platform, because this will be a way to exert a smart pressure for the companies if they do not comply. Because what is the most important for companies is to make sure that they serve their users, so the citizen, the best way.
Okay, thank you very much. I think two very important points. Trust obviously is an issue, and that's what we don't have currently, I'm afraid, because the GDPR has not really yet come to develop the potential and the impact that it should have had. I think many people, we know that from our members' reports, many people are really concerned about how their personal data are, may I say, misused, and they cannot do a lot. So it's this feeling that they are paralyzed. And then about the communication, I think that's an interesting point, and that I would like to bring to you, Andrea. Also, maybe if you can add it to maybe your last word. Do the DPAs need to communicate more to the public or to the data subjects? Thanks.
I think all of you addressed and spoke what the supervisory authorities shall do. We have to be transparent. We have to work closer together. We also have to raise the trust. We have to raise awareness. We have to support the data subject. We have to give guidelines to all the stakeholders. We are trying to fulfill all your expectations, but we have to do it also in the right order, and the order is not always the same, because the companies are expecting completely different issues than the complainants, and the press or the public audience is also waiting for different issues. So the expectations are quite diverse, and we try to unify them and to work for all of you in the right manner. But if I take communication first, then others will say, okay, but the guidelines are more important, you have to give us. So we always have to work between these balances and check which is important most at the moment. And as we are an EU body, and not only a decision-making body, but also a cooperation body, we put the cooperation amongst the supervisory authorities first, because I think the cooperation will help most either the individuals and also the other stakeholders, the companies.
Okay, thank you, Andrea. Indeed, big challenges. Sinan, I don't have a lot of time left, but I'd like to give you the last word from the consumer perspective, please.
Thank you. Well, first of all, we need to have a long, hard look at the one-stop shop mechanism, because currently we feel that it's not working at all. It's not working for the data subjects. We're already in a very bad sort of balance towards the companies that we're trying to enforce these rules against. So we don't have a lot of power and we need more help. The first step could be to actually harmonize some of the cross-border complaint handling. That would help a lot for both consumer organizations and I think individual data subjects.
Okay, I think that was a very concise list of topics. I had understood I have to ask my technical support that we could only last until 25. Now it seems we have 5 minutes left. Is that correct? No. Okay. So technical support BTV says no. So I will then just have to say thank you very much to all panelists for this really interesting discussion. I hope the audience found it interesting and useful as well. Well, let's put up our sleeves and all work together. I think the objective is very clear and the to-do list is long for all of us. So thank you very much for this discussion. Take care. Bye-bye.
Thank you.
Thank
Bye.
you.
Bye-bye.
Thank you.
It was a
Bye.
pleasure.
Bye-bye.